where Megan started off talking to you about, and Grant's going to talk to you more. When we do training for the conflict attorneys, one of the things we talk to them about is professional responsibility and that type of stuff. And in my job, besides doing training stuff and everything, one of the things I do is I get to read all the letters where your clients are complaining about you. Hopefully, before they start complaining to disciplinary counsel. But we get letters every week from people complaining that my lawyer doesn't talk to me. I can't find my lawyer. I don't know who my lawyer is. My lawyer's never been to see me. My lawyer works for the state. And then I get phone calls from mama, girlfriend, wife, just some friend that lives next door is trying to help them out. And 9 times out of 10, it boils down to problems with client relationships. They don't hear from them. They've never talked to you. It's going to take a while for you to get discovery and stuff, but you have to start out with building those relationships with your client. You heard BJ this morning talking about trust and building trust with your client. And if you don't have that, rapport and trust, and sometimes clients are people, and some of them are easier than others, but you're going to be working on building those things. So that's what Megan started talking to you about some with. Grant's going to talk to you about now is how to build those client relationships.
Thanks, Lawrence. Good morning.
Good morning.
Wow, what an enthusiastic crowd. My name's Grant Gibbons. I'm one of the old men in the room. Lawrence actually drove me to my first job assignment when I started out back in 1991. Wow. And I remember those days. And I'd like to talk to you a little bit about starting out in the practice here in the public defender system. It's kind of a different world, having seen countless people come up from the prosecution side and from the public defender side. It seems like there's a common theme that goes on with people just starting out. There's this fear of being embarrassed, this fear of somebody putting one over on you, the other side tricking you, the other side laying a trap that you stepped in. It almost seems like for the first little while, it's easy to fall into kind of a game. And that's something you need to fight against, because these are people and they have lives, and you are a professional and you're trained and you've passed the bar and you have a job to do. All right? So one of the most important things you can do when you're starting out is keep things on an even keel. Nobody wants to get a call from their boss. Hey, I need to talk to you. I got a letter from your client. I got a voicemail from your client. What's going on? Why are they mad? Nobody wants to have their boss come and say that. It's going to happen because you can't make everybody happy. But the more you can do to prevent those situations, the better for you and the happier your boss will be. And it is all about your boss, right? All right. Lawrence hit it. One of the biggest, probably the biggest problem is communication. I have never had somebody call me up and say, my lawyer's talking to me too often. Never had that happen. So that's probably the biggest thing you can do to prevent these situations is keep the communication going. Honesty. When I go see somebody the first time, I don't have their discovery. I may have read a warrant, I've read their charge. They're going to start saying, what do you think? What do you think? Or I didn't do it, I didn't do it. I say, look, we're both grown-up people. Are you going to buy a used car without test driving it? No. Well, that report that we're going to get is our test drive. So it doesn't do any good for us to say, guilty, innocent, plea deal, trial. We're all just shooting in the dark, and if I gave you an answer, it would just be a guess. So let's not even do that today. Let's just talk generally. Let's talk about what your charge carries. Let's talk about bond. Let's talk about your home life. But let's not get too deep into the facts. Because what I don't want to do is have my client say the red light was red, and then I get a video and the light's green. Then we have a problem. And I'll tell my client that. I say, look, I know it's hard. I know, especially if you're in jail, you got nothing to do but think about this all day and worry about this, but we just cannot go deep into the facts at this point in the game. And just be clear with them up front that that's what you're going to do and that's why, and it's in their best interest to do it that way. All right. Family dynamics. All right. I've had many times where my client is just locked down. They're stuck with a story that obviously isn't going to work, obviously isn't straight with me. For whatever reason, they're not going to talk to me. For whatever reason, they've talked to their bunkmate who obviously knows more about the law than their lawyer does, and they're not being realistic about anything, and they're not progressing either toward a trial defense or toward working something out. Many times, mom and daddy can be your best friend. They can also be your enemy, but sometimes you got to get your client's permission to talk to them about their case. But a lot of times you talk to mom and dad, you talk to girlfriend, you talk to wife, and they are a little more realistic about what the facts are and what the chances are. All right? And if you explain the whole situation to them, the law involved to them, sometimes they can help you talk to your client and help them make an informed decision. It's still their decision, but having someone they trust, know the facts, know the law, have an understanding of what's going on, that can be an ally for you if you need to keep them from doing something really stupid. So, like I said, it can backfire on you, but sometimes when you have no other toehold, you got to do what you got to do, and parents and family members can be a good source. When I go meet a client, as I said, you guys are professionals. You got that Juris Doctor, right? So you're actually a doctor. Don't have them call you doctor. But it's sometimes a tendency to get too casual with your client. You know, first name basis and things like that really have no place in the relationship, especially at the start. You want to keep professional. I mean, you don't often go to your doctor and say, hey Bobby, how you doing? You know, unless you've been friends for years. They keep that professional distance. They need to know that you are there as their lawyer, not as their buddy, not as their, bar hopping partner or, their bestie on Facebook. I say Mr. Green, I expect him to say Mr. Gibbons, and we keep it professional. Now, some of my clients, after I've had them 4 or 5 times, it gets a little broken down. But to start out with, keep that professional, especially when you're first starting out. Because it's easy to go from calling first names to them calling the shots, okay? And sometimes you need to tell them. Sometimes you need to be real with them. They need to recognize that you are a professional and you do know what's going on. And keeping that professional title in between the two of you is a good way to keep that where it needs to be. All right, let's kind of flip for a minute. I want you to imagine that you were driving here this morning and you got rear-ended by a bus. Lost consciousness. You woke up at Baptist Hospital in the ER and your legs all wrapped up in bandages, your head's wrapped up, you got a fat lip. You're laying in that bed and you don't know what happened. You don't know why you're there. You just know you're in the hospital. All right. Do you want the doctor to walk in and do this? Hey, Mr. Gibbons, I've read your chart. I've seen this 100 times. I don't really have time to talk to you a whole lot. I got a lot more patients to see. This is what you need to do. Tomorrow morning we're going to amputate half of your left foot because our hospital's too full right now. We got to move people out. How you going to feel? Foster a lot of warm, fuzzy feelings, trust. All right. How often do we do that when we go see our client? Hey, I don't want to hear your story. I know you're lying to me. I know what happened. I read the report. You can say that with your body language as much as you can with your words. And we're all too busy. We all have too many clients. We've all heard a lot of lies. We've all heard a lot of crazy stories. We've all heard that I'm not a criminal. I don't belong here. I'm not the kind of person that can go to jail. We've heard it all. It's very tempting just to brush that all aside and say, look, I know what's going on. Shut up. This is what we're going to do. I'll see you next week. All right? But put yourself in their place, just like you were in that hospital bed. What would you want to hear from your professional coming in there to help you make a life decision? All right? So just slow it down a little bit and try and relate to what they're feeling and what they're saying. They're in that jail, they've got nothing to do all day but think about this problem. And listen to the guy in the next bunk give them all kinds of wonderful advice about it. Come up with some kind of story, come up with some kind of idea, come up with some kind of defense. They're gonna, the minute you walk in, they didn't read my rights, they gotta throw this out, right? No. So try and be a little bit empathetic to their situation, especially on your first meeting. Don't jam up your jail visits or your office appointments to 15 minutes. You got to spend some time. Like I said, you're not going to have a whole lot of information right then, so what else can you talk about? Get to know them a little bit, try and get an idea of where they're coming from, what their big concerns are, what their end goals are, and a little bit about them that you can keep in your mind when you're talking to them. Ask them about their kid, ask them about their mama when you come back to see them the next time. So, be a real person. That's real important. I've had clients that have been a problem. High maintenance, call me 4 or 5 times a day, write me letters, go out and do investigations, complain, whine. I tell you what, if they're in jail and you go and see them after hours or on a weekend, you instantly gain cred. Oh wow, this guy took time off that he didn't have to be working and he came and saw me. Man, I must be important to him. And sometimes that's all that needs to happen to change a bad relationship into a good relationship. Now, like we heard from Megan, try and go home at 5 o'clock. I'm not saying do this every night, but I'm saying if you've got some people that are wearing you out, wearing your paralegal out, this is a great little pill to deal with that situation. You go see them on a weekend, you go see them at night. A lot of times that will diffuse whatever's bothering them or whatever doubts they have in your sincerity or your work ethic toward their case. Now, don't do it every day. I'm going to say it again. Our job is sweeping a dirt floor. There's going to be dirt under it no matter how hard you sweep. So, do the best you can. Take care of yourself, take care of your family, and you'll last a lot longer in this job. All right, preliminary issues. We talked about that. These are just some of the things I get from them when I meet them the first time. And as I said, you don't have a whole lot else you can talk about at that point, and so spend some time, get to know them. Ask them a question that will jog them in your memory. You're going to have way too many clients to remember everything about everyone. But if you remember, this is the guy that works on the high-rise skyscrapers, that might be all you need to kind of jog your memory when you get a phone message of somebody calling you back. You also need to check on their military history. There may be some mitigation there. You may be dealing with somebody with some mental health issues, some PTSD. Unless you know they're in the military, you might not know about that. Same thing, I always ask them if they've had any drug treatment, if they've ever had a mental health diagnosis, get some inside information. Find out what their biggest worry is. We had a lady who had been in an accident, and she needed an operation to get her out of a wheelchair, but she couldn't afford it. So she moved into a little trailer out in the country, and everybody found out she was out there and she had some resources, so all of a sudden she had a bunch of friends coming out there moving in. They all brought their dogs, and they had a great time until the money ran out. Well, they left. They left their dogs out in the yard, and they left her. She couldn't get out of a trailer house. She was in a wheelchair. So about a week later, somebody reported the dogs weren't being taken care of, so they went out there, and there she was. And they arrested her for ill treatment of animals, and they wheeled her into the jail and locked her up. Well, we got involved, and we found her a halfway house to live in that would take care of her, and we got her lined up with a long-term treatment facility. We got her lined up with disability. We worked really hard, and we had her a place to go stay. We had her enrolled back in college, and we put a lot of effort into her case. Well, as soon as we got her situated, she decided she didn't want to do that, and she wheeled herself away. A lot of effort, a lot of expense, a lot of work went into that, and that wasn't what she wanted. So find out what their goals are, what's important to them. We had another guy locked up on a bad shoplifting charge. We recognized there was a problem with the arrest. We hurried down to the magistrate's office, got the officer on the phone, and they dismissed the charge. Well, it was January. This guy was homeless. He walked across the street from the jail and threw a brick through the window of the bonding company so they'd lock him back up. He didn't have anywhere to go. So again, maybe we should have asked him what his goal was, what his problem might be. We're all warriors. We've got these law degrees. We want to go fight the dragon, but we need to find out if the dragon's the problem. So that first interview is really important. Find out what their priorities are, what their worries are, what their concerns are, and try to deal with that. Now, you can't be their therapist. You know, it's tempting to try and fix all the things that have gone wrong, but most of them have spent 20 years getting to where they're at, and you're probably not going to fix that in a 1-hour meeting or a 6-month representation. But maybe you can help. Maybe you can point them in the right direction. But you definitely need to find out what their priorities are and what their concerns are. Oh. All right, we talked about changing their story later. One other thing you do at the first meeting is give them a roadmap of what goes on from there. Do you think you're going to get out? What does your bond look like? Well, I want a bond hearing. Okay. Well, your bond's at $50,000. What kind of bond can you make? Well, I don't know. Well, that doesn't help us, because if we ask the judge for a $40,000 bond and you can only make it $20,000, we've wasted our time. And generally, you got to wait 6 months before you can revisit that. So before we jump up and down and go get you a bond hearing, you need to talk to your people and find out what they can make. And we need that information before we file for a bond hearing, because we might get one the next day and we won't be ready for it. So that's a conversation to have with them. Be realistic, like Megan said. You know, if they're in on a murder charge and they're out on bond on an armed robbery charge, might not be the best idea to go for a bond right now. And I had that conversation with them. You know, everybody's kind of ticked off right now. Why don't we let it cool a little bit? Let the next big criminal get in the newspaper for a few days and let them forget about yours for a little while. Maybe we'll get a better bond. So patience is something we got to encourage when it's in their best interest. All right, always go over what the potential sentences are. And if you don't have the rap sheet, and like it's a drug case, you need to explain to them, look, I know you say you don't have one, or you think you don't remember what it is. I've been amazed at people. I don't know if I have a criminal history or not. Well, I think I would remember if I was on probation for 3 years, but some of them don't. So always, give them a lawyer answer. Based on what you're telling me, this is what could happen. Well, they charged me with a first offense. Well, you've got 4 priors. Well, I know, but my warrant says first offense. Well, I understand, but that can change, and look, give them the straight right up front, so there are no problems later with you shoulda, woulda, coulda told me what was going to happen. We all know that there is a trial penalty. There shouldn't be, but there is. So I tell them a lot of times, if you go to trial, you're going to get up toward the top of the spectrum. And a lot of times, if we work something out, maybe we can get below that, down to the bottom end of the spectrum. It's not right, I don't agree with it, but I need to tell you that it does exist and it does happen. And you don't have to say it's a good thing, you don't have to say it's a bad thing. You say, I don't agree with it, I don't like it, but I think you ought to know if we go in stomping our feet, bad things can happen. And I tell them that, I say, look, we need to kind of decide something before I go and negotiate your case. First of all, we got to read your reports. We got to get your paperwork in. Then we got to go over it. And there are 2 ways we can do this thing. I can go over to the solicitor's office and stomp and yell and scream and get us a trial. Or I can go over there and beg and plead and try and talk them into being nice to us. But we can't do both. If we take one approach, it might cut off the other. So another reason for them to be patient till you have all the information and to start working it through their mind that, it's not going to just go this way because you want it to go this way. Now, they're going to start talking to you, and a major theme that will come through is, well, prison's not going to do me any good. That's not what I need. Well, I hate to tell you this, but these people we're going to be in front of, they're not really all that worried about what you need. And you be real with them. I understand, Lawrence used to say people in hell want ice water, That's true. Doesn't mean they're going to get it. So have the tough conversations up front. I tell them, look, I'm your lawyer, I'm not your cheerleader. And I say, if I go to the doctor and he finds cancer, I want him to tell me I got cancer. I don't want him to tell me everything's fine going home and have a good Thanksgiving. I want to know what I'm looking at. And most people want it that way too. Most people want to know straight up, this is hard for me to tell you, this is hard for you to hear, but this isn't good, this is a bad situation. We're going to do the best we can. Hopefully we'll find some good information in the rest of the discovery we've got coming, but we need to play the long game. If we're gambling with $5, I'd say let's go to trial, but if we're gambling with 30 years, we got to think that through. We got to make sure that's the right decision. So again, patience. Let's take this slow. We're not worried about. They're worried about getting home by Friday. You got to shift that. You got to get them to look down the road, and that's a pretty common thing with our clients. Very short-term planning, if any. I want to get home by the Super Bowl. Well, you got an armed robbery charge. That's a little more important than the Super Bowl. I'll call you and tell you who won. All right. Just some body language stuff. While they're talking to you, don't be, golly, I'm going to throw that through the room. While you're talking to them, while they're talking to you, telling about their life and their babies, don't be on your phone. Not a good look. Make eye contact. Ask appropriate questions. Play poker. You may not believe a word they say. Let them talk. Again, stop them from locking themselves into a story at this point, because we're not to that point yet. But if they want to tell you about their mama being sick or their brother who's always getting picked on?
I know you were saying always make sure during that first meeting, don't let them lock into a story. I just want to get your feedback, 'cause I know a lot of times if I'm going to the jails, speaking with the person, a lot of times I don't have the incident report and everything up front most of the time. So when I go there, a lot of times they just want that on and go on with their story. So a lot of times I'm like, well, you know, go ahead and tell me your side of the story, and then we'll have another meeting. We definitely have to have another meeting. So once I get everything, and then we can compare everything and come back to the drawing board about what we, how we handle it.
Well, I tell them, I stop them.
Yeah.
I don't want them to tell me all the details, because if they tell me a story, they're relying on me. It's real important for them that I believe them, especially with the first meeting. And if you let them tell you a story and later on it's not truth, a lot of people are going to have a hard time backing up on that. And so my practice is I don't let them get into the details. I just stop them. I say, look, it's not going to be good for us to get way down deep in the details. If you want to tell me generally, you know, I was at a party and the guy pulled a gun on me, that's fine. You know, but I don't want to know where I was standing and where he was standing. You know, I don't want them to tell me that until we've both had a chance. And again, I tell them again, you know, we haven't test driven that used car yet, so let's leave it general for now. All right? And when they're coming in your office, how many of them want to bring mom in with them or girlfriend in with them? That's another opportunity to say, look, we can't talk about anything specific while Sweetie Pie's in the room here, so let's just keep it general, all right? I don't let them do it. That's just my practice. Oh, get something and make it in your notes if they've given you permission to talk to Mama, because Mama's going to call you 400 times every day. And if she just hears you say, I can't talk to you till he tells me I can, she's going to call him, or he's going to call her. She's going to call back. First meeting, just say, I say this. I say, if you got sick, who would you want me to call first? I want you to call my mama. What's her name? Her name's Colleen Green. What's her number? I write that down. Is it all right for me to talk about your case with her? Yes. And I put okay and circle it underneath her name. That's my notation. So later on, if she calls, I can pull up my notes. Yeah, I've got permission to talk to her. And
are we obligated to talk to the mama, the baby mama, the sister, the brother, my cousin that paid 10% down? Are we obligated to do
well, you don't represent them. And if they get to be a problem, that's what I tell them. But they can also be a very good source of finding witnesses that are not going to show up for you or for your investigator. And so I give them the benefit of the doubt until they abuse it. If they start wearing me out, I just tell them, look, I don't represent you. I also tell my folks, you know, when I ask them who they'd want me to call if they were sick, if they start giving me 10 different numbers, 10 different baby mamas and grannies and aunts and godmamas, I say, look, you got to give me one, maybe two. And they can call each other after I talk to them, but I ain't got no time for all these other people. All right, so you can kind of nip that in the bud too. There's nothing wrong with that. Explain to them attorney-client privilege that you're going to be.
Sorry to interrupt you on that.
That's all right.
It's kind of like a nebulous question. I don't have it fully formed yet, but how much of an issue is it when you kind of know your client's lying to you? Because I've only been working as a public defender for 3 months. I don't have any murder cases or anything like that yet, but
Yeah.
I have a couple smaller cases where I know the person's, well, I don't know anything, but I think the person's lying.
Strongly suggest.
Yeah, exactly. It's my understanding that the person's lying.
Well,
Can you kind of push back and say like, hey man, I know you're lying. Like you need to be honest so I can help your case.
I don't know if I don't think I would say that to them. What I tell them is, this is what I say to them. Look, the truth's important to you and me and God, but when we get to court, we got to worry about what they can prove. The truth kind of goes out the window.
Okay.
All right? And I might,
go ahead. I have another question.
Oh, okay. What I tell them is that, and then if they're telling me a story, I say, look, I wasn't there. I'm just going off what you're telling me, but 12 little old ladies on that jury, I don't think they're going to believe that. It may be true, but I don't think they're going to believe that, and I'd hate for you to prison over it. You know, just kind of throw that out there. I believe you, but I don't think anybody else will.
That's fair.
How do you handle when, I have a murder case with several co-defendants, and one of the parents was trying to basically be an investigator himself because he knew all the co-defendants. How do you handle that situation? Because he says, you know, he can provide valuable information and stuff like that.
Well, I would pass him off to an investigator in the office.
That's what I said.
And like I said, my investigator is going to go out there with an old cop car and drive in the neighborhood, and everybody's going to scatter, you know, and they're not going to answer the door. If mom and daddy are aggravating, but they can get me phone numbers and addresses and names, you know, I tell them not to get in the middle of something because they could be charged with tampering with a witness.
That's what I was concerned about.
Yeah, I tell them, look, you can be accused of all kind of stuff, and you can end up being the next cell over from Junior. So why don't you let my investigator do the running around, you give them the information, whatever you got. Does that answer your question?
Yes, sir.
All right, yeah, don't have them out there, because I have seen people charged with intimidating a witness.
Well, he did it on his own, and then I told him I would lay off on that until an investigator gets involved.
Yeah, just start off a conversation like this. Look, when you get arrested for doing this, I'm not going to be able to represent you. So. All right, what else we got? All right. Preliminary hearings. Who does them? Some circuits aren't doing them anymore. All right. I also heard some people were sending another attorney to do them.
Yeah, we do that.
We do them as an office, so like in Greenville County, we kind of shifted, and the solicitors as well. Like every solicitor is not calling their case they're assigned to.
Right.
So there's one solicitor assigned to represent the solicitor's office at preliminary hearing for all.
Yeah, that's how ours does it.
Yeah,
At prelim.
we would change to something
Yes,
else.
Well, I got kind of a different take on the prelims. It depends on what kind of case you've got, all right? If you got an important case and you want to get the officer on the stand to lock him into certain testimony, I'm not sure my colleague down the hall is going to know the issues that I need to get locked in. And so if it's an important case and I really need those witnesses locked into something for my defense, I think I would go.
Also, how do you deal, like usually for a prelim, we don't have discovery and all we have is warrants. So like having.
Well, again, there is a law that says the magistrate can't set a bond unless he's been given discovery. And a rap sheet.
We missed that, sorry. Can I say that again?
Sorry. No.
Yeah, missed it.
Hey,
Can you
Um,
sorry?
There was a big dust up about some warrants being issued probably a decade ago. And I think they enacted a statute saying that the magistrates had to have a rap sheet and a copy of whatever initial incident report there was at the time they set bond.
I don't know.
Now, not everybody follows the law. Just because the law doesn't mean they're going to do it. But I don't think it's appropriate for them to be able to show up to the prelim without a report. The officer's definitely going to have a copy of it, right? I don't know that you shouldn't make a motion to them turn over a copy right then, and you have 15 minutes to review it at least, if not more.
Sometimes, I mean,
So-
the first time you're hearing it, I've only done prelims with the benefit of discovery, actual discovery, because there was lower court charges involved, probably once or twice.
Well, you need to get your boss. You need to get marked on that.
Now, honestly, it's like fast break basketball in Greenville County. Like, I have my big blue book with all the criminal statutes in the state of South Carolina. And honestly, I have a list of my clients, and it's a laundry list. And like, you're going next, and it's fast break. Like,
Well-
the elements present, and then I have to cross-examine this police officer who has the benefit of the incident report
Yeah.
that I don't have.
Well, I'm going to give you Grant Gibbons' preliminary hearing theories, okay? So let's say you get to prelims and you are the best lawyer in town and you get the case thrown out. And then next week they directly indict it. So, what have you done?
If I got it dismissed and then it's directly indicted, I have a problem with that, but,
Well, it doesn't matter if you got a problem with it, that's the law, they can do that.
yeah, I mean, yeah, they can do that, but.
And you probably gave them all your defenses, right? At prelim.
No, I mean, I don't have anything, how can I give you my defense if I ain't have anything for it? But go ahead, I'm sorry.
This girl over here. What I'm saying is this, if I did a good enough job to get it thrown out, I've probably tipped my hand on most of my strong stuff to get it thrown out, haven't I? So now they're gonna bring the charge back and they know where I'm going.
So I think that's why in our circuit, we have like a different stance on prelims. So I know I've worked in Greenwood for a while, so they pretty much, it depends on the case as to whether they're gonna most do the prelim, but most of the time they don't handle it over in Greenwood. And Lawrence, on the other hand, we handle it way differently. Like we go to every prelim no matter what it is. Our deputy is like, you're going to prelim, it's good for your practice to learn how to cross examination. It's really, we're using it as a tool to really make sure that the officers do everything they need, and then we stay abreast on our skills. So
Well,
I've had
I'm gonna tell you my,
really think were necessary.
I'm gonna tell you my opinion about that, and it's worth, half a cup of coffee maybe. If you're having 100 prelims, you're probably not prepared for any of them. And you are just filling up a docket and checking a box.
That's how I feel.
Yeah. And nothing says, in South Carolina, you don't even have a constitutional right to a prelim. If they indict it before prelim, you don't get a prelim. So my practice is this: if I'm going to have a prelim, and people in my office do it differently, I don't fuss at them. If I'm going to have a prelim, it's because I need something. Because I found out I want to do something. Now, we request a prelim at Jump Street in our circuit, but they do not schedule it until I send them a letter saying, please schedule our prelim. So we don't end up waiving it by waiting too long, but we're not going to schedule it until I've got discovery, I've reviewed it, and I've decided whether I want to have one or not. So instead of me having 45 prelims that I'm not doing anything but moving a case around on a desk, I may have one that's going to be meaningful. And the prosecutor knows if I ask for a prelim, something's wrong with the case. All right? So that's how I do it. And when I have a big case, a murder case, a rape case, something that's been in the paper, I have a frank conversation with my client. And I say, look, we can have a prelim. We can get it thrown out. They're going to know our defenses at that point, and they can directly indict it, and we're going to have to start all over trying to figure out how to defend it. Not only that, it's going to get in the paper again for all the town to hear about again. It's going to stir the victim up again. It's going to stir law enforcement up again, and it's going to be another wave of press that's going to hit our jury pool. Now, I make an appointment to meet with the investigator. Sometimes the solicitor wants to come, that's fine with me. I talk about anything I want to talk about. I find out anything I want to find out. I ask any questions I want to find out. I don't tip my defense to them at all. I get all the information I need that I would get at a prelim.
From the investigating officer?
I just make an appointment.
Oh, wow.
Just call them up, they'll come over. We'll sit down in the conference room, we'll go through the case. I do that in all my big cases. Once in a while, I want to have a prelim because a cop screwed up and I want to trap him into admitting it on the stand so I can use it against him in the trial. But more common is I don't have a prelim because I don't want to tell them where I'm going, and I don't want it to get in the press again. I want that victim to have another few months to cool off a little bit more or move to Florida. You know?
prelim.
Well, and like I said, my whole office, some of them do prelims on every one of their cases. That's what they're gonna do. And that's fine, I don't tell them not to do that. But I'm just sharing with you another way, okay? Whether you can do it or not, that's up to you, but it's something to think about to make it really a meaningful exercise rather than just basically a roll call and somebody reading a report.
Grant,
Yeah,
when do you have that conversation with them about prelims? Because we're talking about the letters that I get. Usually when I get them early on, one of the most common issues is, besides the fact that my lawyer won't give me a copy of my discovery, is my lawyer hasn't scheduled my preliminary hearing, or my lawyer won't
Right.
schedule my preliminary hearing. And from the letters is, they won't call witnesses. They don't understand what prelims
Yeah.
are for. They don't and nobody.
That's a good
explains
point.
to them, you know, what prelims are for, what happens at a prelim, and and so when do you have that conversation?
I have that at first meeting too. I'm glad you said that. I forgot about that. This is what I say. You have this thing about a preliminary hearing, because when they have their bond hearing, the judge will give them this paper that says you have 7 days to request a preliminary hearing or you waive it. So they're all freaked out about that. We do that as soon as we open the file. We request a prelim. So that's taken care of. So what I tell them is, look, I know you've heard a lot about something called a preliminary hearing. I bet your roommate has told you all about how wonderful they are. I bet you've known 15 people in jail right now that got their case thrown out. Here's what a preliminary hearing is. When the cop got this warrant, he went to a judge and said, this is what we think happened. And the judge, based on what he says, okay, I think you need a warrant. And they went and arrested you. Well, what a preliminary hearing is, that cop goes back in front of the judge and says one of three things. Judge, everything's how we thought it was. Judge, we got more evidence. Or judge, we got the wrong guy. And that's really all that's going to happen. We don't call witnesses. We don't get to put defenses up. You don't get to testify. It's just that cop telling the judge if anything is different from when he got the warrant. And that's all it is. And when you break it down like that, you know, it's not their day in court. It's not their chance to, you know, clear their name. It's a very narrow hearing. And then I have the conversation about whether or not we're going to do it.
I have this thing where, like, if my client can't make it to the preliminary hearing, either they're not transported, like, I never waive it. If they're court appointed, I mean, and you can tell me if that's right or wrong. I don't feel comfortable waiving their right to a preliminary hearing if I'm court appointed to be your attorney.
Well,
I feel like that's your right to waive it. I feel like we still have to hear from the state.
Well,
you can request a reschedule.
But if you do that on everybody who just doesn't bother showing up, you're going to have 200 every week instead of 100. If they have notice and they're out and they chose not to come, that's on them. That's a self-inflicted wound. I'm not going to enable them to make it my problem.
Let it go forward is my question.
Either way.
What's your point in holding that?
I don't, like I said, I don't think that, you know, the way you guys are doing it, I don't know why you have them in the first place.
Honestly, I feel like it's just like a red tape. Like
Yeah.
It's a bureaucratic
Didn't they
process.
mention something at the PD conference this year about waiving prelims without discussing with their clients?
Yeah.
And I can't remember if they said, that there was some like gray area about it being our decision, whether we need to have a full conversation with our clients about waiving it, what it means, all that, or if it's just ours.
Well, if, at my first meeting, if I've explained what a preliminary hearing is, and they've given me an address, and they've given me a phone number, and I've sent them the notice, the court sent them the notice, I've tried to call them, I've left messages, at some point, they got to be a grown-up person. You know? I don't see a problem having it without them there at that point, at least you didn't waive it. A lot of times the judge will deem it waived in our circuit. Well, they've chosen not to be here, boom. But again, what have you lost? Yeah. Bond issues. We talked about bond issues, jail issues. They're not feeding me enough. I don't have my medicine. What do we do about that?
babysitter or make them do something, I would say, hey, she's supposed to get medication, you know, can y'all at least give her to the nurse so she can at least
Right.
figure out how to get that happening. Sometimes just a simple conversation, I
Yeah.
kind of helps out with some of those issues, but other stuff I should kind of just go ahead and let my client know. I don't really know how.
I don't run this place. Let me make a suggestion for you. Talk to the jail, whoever the powers that be are, and see if they will give you a contact person with an email address. All right? It may be the nurse, it may be the lady at the front, or the guy that runs the whoever. Ask the jail to give you a person, a contact person. And when you have issues with your whole office, you know, Johnny says he's not getting his medicine. Dear Officer so-and-so, inmate Johnny says he's not getting his medicine. Send it. You got a copy that you did something, right?
I'm sorry?
You send an email, you got a copy that you did something, right?
Yeah. Hey, you're right. I don't think it'll be cool.
So I think that can be helpful. That way if,
I was gonna say, something I run into a lot though, is my clients are saying the jail isn't doing something, then when I contact the jail, they have a full record of everything that they've been doing.
but your client knows if you sent that email, you've done everything you could do. You'll get an email back and said he had his medicine every day last week. Fine, you did what you needed to do. Didn't hurt. Electrons are free, right?
I send in social work, like I give a referral to our social worker, and I say we got a client that's medicated, that has a history of mental health, can you assure they're getting their meds?
Yeah.
And they usually work that out.
Yeah. Another thing I've run into, I go in there and my client says, hey, they got my co-defendant in the same cell block. That's a problem. And the jail will appreciate you telling them. So keep an eye out for that kind of stuff. That can be a real problem.
Oh, God.
Yeah. Who all knows this?
First meeting when a client emailed a disciplinary rule to me, and I was like, congratulations. You
What about this one? I want my motion.
My personal favorite. I'm gonna get it.
I say,
My motion for
okay.
discovery.
I say, okay, first of all,
What do they call that?
it's called your discovery or your reports. Second of all, asking for your motion is jail language. So obviously you're talking to some experts in the pod back there. I want to tell you, if they knew as much as they tell you they knew, they wouldn't be in jail. All right? Just because I've been to the hospital doesn't make me a doctor. And if I've been in the hospital 15 times in the last 6 months, it makes me worse than a doctor. All right? So I try to discourage them from talking to folks. I also, if they demand their discovery, I am obligated to give it to them. I try and talk them out of it because invariably something goes wrong with it. I said, this is what's going to happen. I'm going to give you your discovery. And whether you share it with somebody in the pod or they look over your shoulder while you're reading it, you have to remember everybody in this jail has a case and has a motive to do something to help themselves out. And if they look over your shoulder and read that there was a red truck involved, they're going to call their lawyer and they're going to say, he confessed it to me and he said he was in a red truck. And guess what? You got another witness against you. I will come over here and I will share your discovery. I will go over it with you. I will share it all to you. I will read it to you. I'll have my investigator come and read it to you again as many times as you want. I'll give you a copy of it if you really, really, really want it, but I really, really, really wish you wouldn't. And most of the time they still want it, but I feel I've done all I can do at that point. I've also suggested we give it to their mama instead. You know, I just, when 9 times out of 10 I get a jailhouse snitch on it, I want to be able to say I told you so. You know, don't blame me. I tried to talk you out of it. But it is their decision at the end of the day whether you give it to them or not. All right? Now, how many times do you have to give it to them? One time. And keep proof that you gave it to them. Because what's gonna happen is they're gonna get mad and flush it down the toilet, or someone's gonna steal it, or they're gonna roll a blunt with it and get it confiscated, and they're gonna go to corrections, and for the next 5 years, they're gonna want a copy a month, and your boss is gonna get mad because you're killing all the trees in the forest. All right. We talked about that. All right, we want to know about any diagnosis they've ever had. Almost everybody has ADD. I can't believe how many people have ADD. And if they don't have ADD, you got bipolar. So we need to be aware of these things and get a release from them and get the records at Jump Street. That could have all kinds of ramifications. Even if they're fine, even if you think they're okay, people change. People spend a little time in the jail and they deteriorate.
This is literally been something I've been struggling with. I've only been practicing in criminal defense about 6 months, but how do you know when is the time, as it relates to the mental health, to order the mental health evaluation? Because a lot of our clients are, well, effed up. Like, how do you, like, where's that line?
Well, have you ever had a judge do a Blair hearing? Competency hearing after they get the report back? The judges are required, if you've had an evaluation done, the judge is required to have a Blair hearing before sentencing or before trial. Because there's been an issue raised, the court has ordered an evaluation, and the judge has to make a finding that either they are crazy or they're not. It can be done off the report, or either side can require the doctors to come to court and explain the evaluation that they did, okay? So once you've had an evaluation done, it's mandatory. But in South Carolina, a carrot is competent to go to court. Do you understand what I'm telling you? Do we have communication? Not that you agree with me, but do you understand what I'm telling you as your lawyer? That's one of them. Do you understand the difference between right and wrong? That's about it. So they can have all kinds of issues, but if they're able to understand, you're able to communicate their case with them, and, you know, they may have delusions of grandeur, they may think they're Napoleon, but if they understand your communications with them and they understand right and wrong, that's it. So, and again, if I'm going to have a state-ordered evaluation, that's going to lock them up for the next 6 or 8 months. You know, and they could have a 30-day charge. So what are we really doing in their best interests?
But don't we have to, if like we're really concerned about their competency, don't we?
Well, are you a shrink? I'm not.
There are some alternatives. I have this one client that we got him to sign like a fine for transfer court.
Mm-hmm.
For small potatoes like that, so you can drop it down to something and just have a signature and just.
Yeah, and if you talk to the solicitor, a lot of times if they're borderline,
Yeah.
I mean, there's some that kind of go like this. One day I talk to them, they're fine. The next day I talk to them, they're not. And so I don't know where that line is, and I don't think the experts can know where that line is. But I know what the judges are going to say. Do you know who I am? Yeah, you're the judge. You know what my job is? Yeah, you're going to decide my case. You're going to decide my sentence. Who's that guy next to you? That's my lawyer. What's his job? He's going to help me out, keep me out of trouble. What's that guy do? He's the prosecutor. And if they answer those questions, you know,
They're competent, just like.
the judge is going to find them competent. And so I just got to be prepared for that. Now, I know an attorney who, anytime his client doesn't accept a plea agreement that he thinks is in his best interest, he orders an evaluation. So you wonder why the system's stocked up. So, you know, I'm not a psychiatrist or a psychologist, but I know what the questions are, and I know what the answers are going to be when I talk to my client. And so you got to make a judgment call at some point. Like I said, he may be out in 2 more weeks, or I can sit him in jail for another 8 months, get him in line for an evaluation. What's in his best interest? You know, it's not rocket surgery, is that right? No. Sometimes you got to do what's in their best interest. A lot of times they're going to say, I was out of my mind, somebody gave me some drugs, I was drunk, I shouldn't have to go to jail because I was drunk. You need to explain to them about voluntary intoxication is no defense, so they understand that. If I think they're playing I'm crazy card, I'll say, look, here's what happens. If you get found guilty but mentally ill, you go to the prison. You may go to the hospital in the prison, but you still go to the prison. If you're found to be insane, they're going to send you to the state hospital. And you're going to have to stay there until they decide you're all right. And if they decide you're all right, then they can take you back to court when you get out. So where are we going here? You know? If you want to be in a prison, in a hospital with a bunch of crazy people 24/7, you know, I don't know if that's where I want to be. So you need to kind of cut off some of the little games people think they know. You know, I had a client tell me, I watch plenty of Law and Order, I can represent myself. So you got to cut off some of those things. You can get in a mess with conflicts. So one of the first things you need to ask them, was anybody arrested along with you? Or was anybody arrested for the same crime you were? What we don't want to happen is you go through your first meeting, you order discovery, you file your appearances, you get 3 months down the line, and then you meet another guy at the jail that has a hauntingly similar set of facts, and you find out you've got a co-defendant. That causes all kinds of problems. Sometimes you have to conflict both of them out. Sometimes you have to conflict one of them out. Then sometimes whoever they get conflicted to thinks, you know, the client thinks you're giving them the runaround, or you're going to go tell on them, or you're turning on them. Make it a point, your first meeting, to find out if there's a co-defendant early on in your questioning. Just because you've represented them before, or you've represented someone that's a witness before, doesn't automatically mean you have a conflict. A good test is, by me knowing or being involved with A, did I find out anything that I could use to hurt B or to hurt A? So talk to somebody that's been doing it a while in your office. Don't just say, well, I recognize this name, I've got a conflict, because it really isn't that easy. And especially if you're in a very small jurisdiction, everybody knows everybody. They've all been through the office 15 times. Last month they were a victim, this month they're a defendant. So you're going to have to kind of get a knack for what really is a conflict and what isn't. But some of the higher up lawyers in your office can help you do that. Client's family, talked about that. All right, I want a fast and speedy trial. Y'all ever heard of that? Yeah. All right. So you can say, okay, well, we filed that today. They put it on the trial for next month. We don't have discovery yet. Do you want me to get ready for your trial the day before the trial, or would you rather have me be ready when I'm ready? Also, I can't, in good faith and legally, file a frivolous motion. And if I'm not ready to go to trial, I deem a speedy trial motion a frivolous motion, especially if I just met you today. So that's one. There's some things that, client, there's some things you control and decide. There's some things I control and decide. Filing a motion is one of those that I get to decide, and I want to practice law for a few more years, so I am not filing a motion that I'm not ready to be heard on.
Also, usually they don't want an actual trial. They
No.
want their day in court complete.
They want a speedy bond hearing or speedy PR.
My line is always, there's no such thing as a speedy plea. Exactly.
All right, what else we got? All right, here's my office approach, and don't tell anybody this, okay? Let's say your client calls your boss. Mr. Gibbons, my lawyer hasn't seen me in 2 months. I haven't got my motion, there's that word again, and he won't call my mom back, and they're not feeding me a vegan diet at the jail. All right? Don't laugh, I get those. So, here's what I do in my office. I forward that email or that letter to his attorney. And I say, my employee, I got one of those sweet letters from your client. Please write up what you think my response should be. And so they write it up. I read it, I check the records and defender data, and I may change a thing or two, and I send that to the client. That way, you know what's going on, I know what's going on, and client knows what's going on. But, again, that's not where we want to end up, right? And what do we say at first? What's 90% of the complaint? Haven't talked to my lawyer. Or this microphone. All right. Grievances. All right. ODC complaints. You're going to get one. It's going to crush you the first time. It's going to be the end of the world. All right? But it doesn't have to be all that big of a deal. My solicitor's office got their first one several years ago, and they went to the council and they wanted to they wanted a budget item for a retainer to hire a civil lawyer to do all their ODC answers. Because that was scary. They never had one of those before. All right. I don't think any of us have that luxury. If we get a complaint, guess who's going to write the response? Y'all. Okay? And again, usually 99 times out of 100, it's just complete the same thing that they're complaining about to me. My lawyer hasn't seen me. My lawyer's not acting in my best interest. My lawyer's working for the state. My lawyer hasn't got me a hearing. I wanted a speedy trial. My lawyer wouldn't file it. It's usually that kind of stuff. Now, everybody uses defender data? The most beautiful thing about it is notes, right? So, I write my complaint answer, and I answer it line by line. Okay, you think I was doing A. Here's why I wasn't doing A. You think I was doing B. Here's why I wasn't doing B. And I go all the way through it. And then I pull up my notes, and I hit print, and I staple it to the back. And if I've taken my notes, they should show when I've gone to see him exactly what time and day, what we discussed, every call from his mama, every call back out to his mama, every time they missed an appointment, I make a note in the notes. And that's 90% of your answer is going to be in the notes. It's going to be clear. If you've done your job, if you've kept your notes how you should, they're going to read that and roll their eyes and dismiss the complaint. But if you're slack and you don't write down every phone call and you don't write down every meeting and you don't make some kind of note about what your meeting was about, those notes are going to hurt you. All right? So my theory is when I get a complaint, I bury them with information. And I've never had that go wrong. So defender data is a wonderful thing. It will save your butt. So take good notes and notate everything. If I get a voicemail, I put in, I got a voicemail on this date. Return a voicemail, return voicemail, phone number disconnected. I'm covered, right? Client's address no good, letter came back. Client's phone disconnected, client's phone not working. If they say I'm not contacting them, what does that tell? How am I going to contact them? They didn't give me, they didn't update their information. My notes just saved me. All right. Okay. I get a call from a defendant at the jail. Hey, I want a different lawyer. Why? Well, my lawyer's not doing his job. Okay, what's he not doing? Well, he acts like he's working for the state. All he wants to tell me is bad news. Okay? Now tell me exactly what he didn't do that you think he should do. All right. All right, so if I get that phone call and I don't want to mess with it and I just reassign it to somebody else in the office. All right? And that guy's, what's he going to do when he turns around and gets off the phone? Hey, y'all, I got a different lawyer. So what's going to hit my office?
Everybody wants a new lawyer.
And it'll jump from pod to pod to pod, right? All right. Okay, so what happens if someone files an ODC complaint and I immediately assign them to a different lawyer?
Everybody gonna file an ODC complaint.
So in my office, my policy is once you're on the pony, you're going to ride to the end of the trail. Okay? Now, there are times when things just get so crazy that I've had to make a change or my attorney's going to kill himself. So I do it once in a while. But I have all my staff know, and you guys need to know, it's not that we're being mean to you or we want you to have this terrible client. It's just he's not going to be any better for the next person, and it may cause a ripple effect. And so if you got a jerk client, you know, hate it for you. We've all been there. That's why we love being public defenders, right? All right, I think we're out of time, man. Did I go over? I'm sorry. God, y'all just tell me to shut up. We didn't even talk about holistic. Well, again, I'm Grant Gibbons. I'm in the Second Circuit. If y'all ever need anything, give me a holler, and I can tell you I don't know. No. It's a pleasure to have y'all here. I wish you a lot of luck in your career. If you haven't been to 102 and 103, I'll see you then.
And before you finish, you're talking about the bail statute and the things that the magistrate's supposed to have.
Mm-hmm.
That's all in section 22-5-510.
See, I didn't make that up.
And it talks about the things that the judge is supposed to have. If law enforcement has not provided them, they have to give an explanation of why they haven't provided them, but that's not an excuse not to proceed with the bond hearing, except in CDV cases. And in CDV cases, they have to have that information, and it has to occur within 24 hours.
What was the code again?
22-5-5-10.
And again, if,
You said it's specific to these.
You said 22,
5. 22-5-5-10.
again, that may not be a windmill y'all need to go bump up against, but it's maybe a conversation you need to have with your boss and some of the other attorneys.